Hello. The Divine Code reading for December 20th, pages 391 and 392. We're in the chapter Details and Examples of the Prohibition of Murder, subchapter Causing Mortal Injury and Partners in Murder. So for the main chapter, this is the second topic of the subchapter concerning partners in murder, and it's topic number 20 for the chapter on the details. 10 people who hit one individual, one after another, and killed him are all murderers and are all put to death. If each of the 10 hit with a lethal blow. So you have 10 people that all hit the person, and in yesterday's reading, we were learning about there's a period of time between the delivery of the lethal blow that's expected to kill the person and the actual time of death. So in this interim time, you get a group of people that are all giving a lethal blow to the person. In that case, each person is considered part of the murder. Rabbi Zalman Nehemiah Goldberg notes that if 10 Jews hit one person simultaneously and killed him, all are exempt from execution. In Tractate Bava Kama 10b, Rashi explains that since it is not known who killed the victim, and the same should apply for Gentiles, for whom the law is lenient in cases of doubt as to capital sin. So according to, there's an understanding in Rashi that if 10 people all delivered a lethal blow to one person, and each one of those blows in and of itself could have killed the person. The Divine Code just said that each person is liable. Now Rashi has explained, based on Bava Kama 10b, that that would not be the case. And because it's not the case for the Jew, also in the case of a Gentile, in cases of doubt, because you're not sure which person did the lethal blow. So in a case of doubt, it's the laws are lenient towards a Gentile, generally speaking. Murder is in a different category than the rest of the no-hide laws, it should be pointed out. But the way it's being explained here in the footnote, each person would be exempt from capital punishment because it's doubtful as to which person did it. But then it goes on, the author cites Tractate Sanhedrin 78a, Rashi's explanation there, and Rambam, Laws of Murderers 4:9, that a Jew in such a situation is exempt due to the verse, Leviticus 24:17, a man who hits one of all men, which teaches that a Jew is only liable for killing a victim solely from his own actions. So the Jew learns the law from Leviticus that a Jew is liable only for his own action in the case of murder. However, a Gentile is liable by the commandment Genesis 9:6, one who spills the blood of man, which implies that any amount of murder, individually or shared. So the no-hide law is learned out from a different verse that would not give that exemption. That exemption is found in a verse that is specifically for the Jewish people. So for the broader no-hide law, that exemption would not exist. Therefore, Any one of the Gentile attackers who puts enough power into a strike to kill is liable for murder. So if one person were to deliver poison, and someone else came along and chopped off the person's head, both people would be liable for the murder, according to what's being said here. What is the ruling? No, those in the group who did not hit with a blow that had the capacity to kill are exempt from capital punishment. And that'll be discussed more in topic 23, which will be in tomorrow's reading. So if there's a group of people and some of the people are delivering lethal blows and some of the people are delivering non-lethal blows. So some people are doing things that will kill the person. Other people are just doing things that will irritate the person. The people that did the action to kill the person, those are the ones that would be liable for murder. What is the ruling if two people strike a victim to his death, one after the other, and neither had the power to kill him on his own? Okay, so now instead of individuals delivering lethal blows in succession with each other, so that each person that delivered a lethal blow would be liable, and the people that do not deliver lethal blows would not be liable. Now we have a different situation where a group of people or two people both did, let's say 60% lethality, and together their action pushed the person into death. But individually, they would not have killed the person. If the first person striking would not have killed the victim, but it weakened him enough that the second person strike killed him, then only the second person is liable as a murderer. See Mary on Tractate Sanhedrin 78. So we would have to, I would assume, I would think that the second person would have to do this with the intent of murder. Because if he didn't realize, if the person did not realize that the victim was in a weakened state, and he was just going to, his intention was to send the guy, to attack the guy without murder, then one would think that that would not be considered murder, but it may or may not be the case. The person still shouldn't be doing it, and his action is what caused the person to die. And whether the intent is important, we don't see yet, or maybe it's not important. That's not clear. If one person throws a victim off a roof, from which the victim would certainly, if one person throws a victim off a roof, from which the victim would certainly die, and another person held a sword beneath the falling victim, onto which the victim fell and was killed before hitting the ground, both the attackers are considered murderers. Tractate Baba Kama 26b, comparable to the discussions in Tractate Sanhedrin 78 of 10 people who lethally hit one person. It is like the case of the attackers who strike a victim one after the other, each with a lethal blow. So in the case where one person pushes them off the roof, and the other person kills them on the way down, both actions would have the ability to kill, and therefore both people would be liable for the murder. Two people. Topic number 21. two people who committed one act of murder simultaneously. For example, if together they pushed a victim off a high cliff, or together held a victim underwater until he drowned, or together lethally struck the victim with one club or sword. They are both considered murderers and are both liable to capital punishment. If both the attackers could have accomplished the murder with his own power, or if either of them could have accomplished the murder individually. So in either case. See Rambam, Laws of Murderers 4:6, and Keshev Mishnah there, that this is equivalent to the law for 10 people who consecutively struck one victim with a lethal blow and killed him. A Jew is exempt from capital punishment for this unless he is the last attacker. According to the traditional meaning of the verse in Leviticus 24:17, a man who hits one of all men. This is unlike the Noahide code for a Gentile who is liable for being any one of those who lethally struck the victim, as explained above in footnote 57. So it's possible that in the Jewish law, this is another example where there's a difference in the Jewish law. If two Jews attacked one person simultaneously, they both pushed the guy off the cliff, and it required both their strength to push the guy off the cliff. There might be a difference in the law, but for a Noahide, the law would be that both people are considered equally liable for their combined effort. The concept of two people who sinned simultaneously and were only able to do so with both their efforts has different approaches, has different applications in Torah depending on the nature of the sin involved. So this case of two people simultaneously pushing a guy off the cliff, there might be other examples in Torah law where it's handled differently. But in the case of murder, both would be considered liable for the action that they did together. Rashi on Tractate Sanhedrin 78a explains that two Jews who strike one victim together are exempt from punishment in the Torah law court due to the verse, Leviticus 24:17, a man who hits one of all men. And not simply because they are two transgressors. This implies that if not for the oral Torah exegeses on this verse, each attacker would be liable. And if the death resulted, as if the death resulted from each one's power alone. So if it was not for the verse in Leviticus, then both people would be considered murderers when they work together. So they're still going over the same question of the difference between the Noahide law with regard to partnership and murder and the Jewish law regards to partnership and murder. See Rashba on Tractate Bava Kama 53b and Or Shemek Hilkot Shabbat 10:23, who differentiates between the following two cases. If 10 men struck the victim simultaneously, and the victim died as a result of their actions, then each one is only responsible for a part of the end result. But if two people push a victim off a cliff, The resulting death is one full action caused by both of the attackers together, and they are both fully responsible. Even Rambam, who disagrees with the Rashba in regards to the judgments of both instances to be the same, does so only in regard to the Jew who murders, for whom there is a special exemption based on the verse, that's the verse in Leviticus, a man who hits one of all men. But for Gentile attackers, Rambam would agree that each individual who lethally struck is fully liable to punishment. Furthermore, since a Gentile is also held responsible for indirect murder, even in the first case cited by Rashba, 10 attackers striking simultaneously, a Gentile would be liable to punishment for this, since the actual death resulted from the striking done by each individual. So what they're showing is the progression of different different levels of responsibility in different scenarios, and showing in showing that where there might be an exemption for the Jew, in finding out exactly where that exemption would lie, and then showing that this would be, even though the other case where the Jews, where one Noahide after another attacked a victim, each one with a lethal blow, that would be that would be liability for each one. Likewise, for a Noahide, the exemption would even be less so for the Noahide who work together in one action. I think that's what they're showing here. The conclusion: it appears that if two Gentiles struck the victim simultaneously and caused him to die, if neither or both of the attackers were capable on their own of killing the victim, then both are liable to capital punishment. Because they're working together. This is different from a person that is part of a group that does less than the necessary amount to kill a person, because they're working together with another person, and this assumes that it's being done deliberately. It assumes that the perpetrators are working together deliberately, and deliberately working together to kill the person, and then they kill the person by their united action. Their action where they're doing the whole thing at one time. If one of the two was exempt from punishment due to some other factor, even if the death could only have been caused by both of them acting together, such as a minor acting together with a mature person, then only the one who can be held liable should receive capital punishment. So if one person of the two intended to murder the person, and the other person did not intend to murder the person, and was not aware that what would happen, or if one of the two people would be exempt because he's a minor. You got a 10-year-old and a 20-year-old pushing a guy together off the cliff. The 20-year-old couldn't do it by himself, so he's got the 10-year-old helping him. The 10-year-old would not be punished for the capital sin, but the 20-year-old would be punished. even though the 20-year-old could not have done it by himself. So each individual would be, they're not being judged together in the court. Each individual is being judged individually within the court. If more than two Gentiles are involved, together in killing a victim, and none of these attackers could have accomplished the murder individually, but when they all participated together, they are all considered as assistants to murder, but they are not liable to capital punishment. See Orkheim, Bereshis 2011. And Bereshis 2011 talks about in Egypt, people would gang up to kill a man to steal his wife. And so the commentary would be discussing the implications of them ganging up together like that. So if it's partners, if they're two people, and they both did the action together, they're both considered to have done at least 50% of the killing. It's just broken apart that way. So it reaches a threshold. If there's more than two people, then they would take it and say, okay, now it's 33% or 25%. Then it doesn't reach a threshold for being considered each person receiving the capital sentence for that. It should be pointed out that there would still be liability in the court of heaven. And the court of heaven is able to see each person what they were doing. So the person is not going to just walk away. Also, courts of law can and should deal with issues regarding safeguarding society, having a functioning society. That's the purview of the courts of law, and that will be discussed more in the later part of this book. But as far as the Torah law mandating capital punishment, that would not be in the case of a larger group. It could still be in the case of a court determining that, however. This is based on the principle that when three people can accomplish one activity only with their equal participation, each if them is considered in Torah law to be the third person who only assists, who is considered unneeded and therefore exempt from punishment. Likewise, if only one of them was capable of killing the victim on his own, the two or more incapable ones are only considered assistants and are not liable to capital punishment. Now, does that mean that if a person has the capacity by himself to push someone off the cliff and he gets two other people to help, would he be liable or exempt because he had two people helping, even though he could have done it by himself? That will apparently be handled in tomorrow's reading. And if one person, if two people are working together, or three or four people, it's broken up according to percentages because they're considered to be equally working together. So there's a difference. If one guy could have done it by himself, then he would be considered not needing the other people. The other people are just assistants who are kind of cheering him on, but he could have done it by himself, and therefore you'd be considered the murderer. I think that'll be in tomorrow's reading. If there's a group of people and one person can do 75% of the work himself, and he just has the other two people helping him do the rest of the pushing, but he needs the other two people to do the pushing, to do the murder. then the responsibility is broken up equally amongst them. So the 50% would reach the threshold, and the 33% would not reach the threshold, according to what's being said here. Oh, it's today's reading. However, if only one of the attackers had the power on his own to commit the murder, while the other was not capable of doing so on his own, only the one with the capable power is liable for capital punishment from the court of law. So in the case where one person can do it all by himself, but he has another person along for moral support, the one person who could do it by himself would be considered the murderer, and the other person is considered an assistant. This is held throughout the Torah, throughout the Torah that one who assists in a sin but has no ability to accomplish the deeds on his own is judged in a court of law as if he had not committed an offense, as explained in Tractate Shabbos 93, Rambam, Laws of an impure person who enters the temple 5:18, and responsa of Khatam Tzvi, chapter 82. Regarding divine punishment, it is unclear whether the assistant who murdered to murder is regarded with the same severity as one who commits murder on his own accord. So there's differences in the divine system that between what's called death by heaven versus punishment by heaven. Death by heaven means that the person will meet his demise earlier. Punishment by heaven means that he'll be handled in some other manner. So it's unclear in that regard, but in the Torah court, it's clear. He may not even be liable as one who sends a mercenary to kill. See or Archaim Bereshis 37:31, who implies that in the case of 10 Gentiles who together killed one victim, all of them are not liable for capital punishment in court, but they are all liable for punishment by God. This implies that they are all liable to the same punishment, death, but only by divine retribution. It appears that if the king or the court deemed it fit to execute assistance to murder based on the particular situation, they are entitled to do so. See responsa of Ritvash, chapter 251. So the king, the court system, when it says the king, they're referring to the court system, the dinam, the ruling authority can determine that an assistant, even though he's not by Torah law liable, the assistants can also be punished, either through execution or some other punishment determined by the local government. Thank you.